Good morning, guys. We are here in Judge Stevens' courtroom today. We got a couple of hearings. The first one, the guy was stalking his girl and his two kids, and he's here for a bond reduction. It's kind of a doozy. He's got a
Okay.
$100,000 bond, and the judge is really struggling with lowering it. But they don't get into too many of the details. But what they do give is pretty hectic. The grand jury did find probable cause to indict him, and the lawyer is really fighting for him. And then the second one, the guy is just an absconder for a year. He it's kind of weird because he did go to jail twice, and he got let out on PR bonds while he was absconded, so he kind of slipped through the cracks. But he's here for a revocation hearing and sentencing, and this one's a kind of a doozy too. So,
I don't have
guys,
any
strap on,
problem with that.
enjoy. All rise. Court is now in session.
Did you just hand it to them?
I don't know if I did or not.
I think that's the file you just gave her.
It's a red, so it probably.
Oh, I just gave it to her. Yeah. I don't even, okay, let me pull it. Okay, it's 23 CR 1843. You were Ryan Latina.
Yes, sir.
You were charged here with stalking. And go ahead.
Your Honor, I filed a writ. The bond is set at $100,000, which we're alleging is excessive, and we're asking for a bond reduction. That's for the reasons enumerated in the writ. And I'm prepared to elicit some testimony.
Go ahead.
From the defendant's.
Go ahead.
Sharice Connolly. Where do you want her to be positioned? Your
That's
Honor?
right.
Well, actually, just skip.
Raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Yes, go ahead.
May I proceed, Your Honor?
Yes.
Would you identify yourself by stating your full name and spelling your last name?
Sharice Noel Conley, Conley.
Ms. Conley, how are you related to Ryan Latino?
Small.
In connection with this writ hearing today, I asked you to get some information from different bondsmen. Do you recall that?
Yes, sir.
And did you do that?
Yes, sir, I did.
And which bondsmen did you contact?
Allied, Bell America, Professional Bell Bonds, and Outrage.
So actually, you spoke with 4 different bonding companies. Is that correct?
Yes, sir.
Are all of those licensed to do business in Jefferson County?
Yes, sir.
Now, did you make the inquiry of the first bonding company, which would be Allied, I believe, as far as what the financing and charges would be for a $100,000 bond?
Yes, sir.
And what did they tell you regarding what their bonding fee and financing options would be for a $100,000 bond?
$10,000. We would have to put down $3,000 and pay $500 to $1,000 per month with 2 co-signers.
And would be specific requirements regarding who would be acceptable co-signers as far as financial security?
Yes, that would be my husband
And yourself?
and myself.
And you were both you and your husband were acceptable co-signers to them?
Yes.
What about a bond in the amount of $50,000?
For Alan.
Yes, ma'am. Oh, these are all for, I will start with Alan.
$5,000. They said per month would depend on the co-signer and the job that they have.
Okay, and then did you also make inquiry for a $10,000
A $10,000.
$10,000 bond?
Yes, sir.
And what they
It's the
advised you?
same per month, depending on the co-signer.
And what would be the down payment on the $10,000?
They didn't tell me that. They just were telling me the per month for the $1,000.
For the 1,000. And then the next one you contacted was Bail America, is that correct?
That is correct.
And what did they advise you regarding their requirements for $100,000?
$2,500 with $200 per month for 2 co-signers.
So they were, what was the total fee for a $100,000?
I think it was $2,500. I didn't write that down. Oh, I'm sorry, $10,000.
10% of the total bond.
That is correct.
So they would charge you $2,500 down and a total fee of $10,000. Is that correct?
That is correct.
And then the monthly payments would be what?
$200 per month with 2 co-signers.
And did you make inquiry regarding a $50,000?
I did 5,000 for 150 per month with 2 co-signers.
What was the down payment for 5,000? 5,000 is the total fee. What was the down
Correct.
payment?
She didn't tell me.
And as far as a $10,000 bond, what was the total fee?
$1,000 with $100 per month. She didn't tell me a down payment.
And then professional bail bonds, what was their total fee for $100,000?
The total fee was $10,000 with $3,600 down, $300 to $400 per month.
And what about co-signers?
She didn't say co-signers.
And then what about a $50,000 bond for professional?
$1,800 down,
For a total, what's the total fee?
5,000.
Of which they needed $1,800 down?
$1,800 down.
And per month, what would the financing be?
$300 to $400 per month with $150 to $200 biweekly.
All right, and then it's finally with professional with a $10,000 bond, what was the total fee?
$300
The
down,
total fee,
$1,000.
and what was the down payment for?
$300 down,
And
and then pay out the rest
Alright.
either biweekly or per month.
then the last company was Al Reed Bail Bonds, is that correct?
That is correct.
And what was their total fee on the $100,000 bond?
$3,000
No, the
down.
total fee.
$10,015.
And then what-
$3,000 down.
3,000 is a down payment, and then how much would the financing be on the balance?
They could not tell me that.
Okay,
It's based on the cosigner and the job.
I got you. And they require co-signers as well, is that correct?
I believe so, yes.
How many? One or two, do you know?
2,
And were you and your husband both acceptable co-signers to them, or did you ask?
yes.
What about a $50,000 bond for Al Reed?
$5,015 with $1,500 down.
And again, the monthly payments will be contingent upon the co-sign.
Correct.
And then finally with Al Reed, what was the total fee for a
$1,015 with $275 down.
Now, obviously, Mr. Latino is responsible for his bond and
Yes.
payment of the bond fees.
That
Are
is
you
correct.
familiar with his financial circumstances?
Yes.
What are they?
He was doing work from home. And that's,
Okay, and he no longer has that job since he's been incarcerated, is
that
that
is
right?
correct.
Does he have any savings?
Yes.
How much are in his savings? Do you know?
Maybe $800 to $1,000.
Okay. Does he have any other assets, liquid assets, money?
Yes.
What are
Yes, he
those?
does have assets. He has equipment that he could sell.
What kind of equipment?
Trailer, a side-by-side, a 4-wheeler.
Okay, how much do you think the total could be raised?
There's no way to get one of those guys. And that's all.
$2,500 to $3,500.
And what would be the amount of time that would be necessary to try to get those things? How much time would that take, do you know? In order to raise-
A month, maybe less.
Any other real estate, property, anything like that? Any other vehicles, stocks and bonds?
No, sir.
So basically, he has a trailer, 4-wheeler, and around $800 to $1,000.
And a side-by-side, yes.
What is a side by side?
It's, that thing that you ride in on off-road.
Okay, I'll
Oh,
ask.
and a motorcycle, I'm sorry.
What's the motorcycle?
I don't know the model, I don't know.
Does he have clear title to all those
Yes,
things? or are they-
yes, he does.
or-
Yes, sir, he does.
Do you know if he's trying, obviously he's still in jail, so he hasn't been able to facilitate payment of a $100,000 bond, is that
That
right?
is correct.
And you made efforts to do that, is that right?
Yes, sir.
And obviously you and your husband aren't responsible for that, that's Mr. Latino.
That is correct.
As far as his ties to the community, where would he live if he were on bond? And out of
Well, he
jail?
has his own house.
Where is that located?
It's in Hardin County.
What's the address?
I think it's 9025 Dogwood,
And what, is that
Lumberton.
Lumberton, all right. And he would be residing there by himself?
Yes.
And as far as his background in the community, how long has he lived at that address, or do you know?
He has lived at that address for 4 years.
And how long how long has he been in the Southeast Texas area, Jefferson County, Hardin?
All of his life.
Whole life.
Yes, sir.
Doesn't that ties to other parts of the state or
No,
other
sir.
states?
No, sir.
So you agree he has substantial ties to the community? Is that right?
Very much so.
Did you ask about what the cost of a GPS monitoring device would be in addition to the bonding fees? Should the court impose that with the bonding fees?
I did. I think they said there was a price to get it, but then it was like $220 a month.
So in addition to, if the court were to impose a GPS device as a condition of bond, there would be an additional $220 a month, but in addition to whatever the bonding bill was, the bonding
Yes.
payments would be, is that
Yes, sir.
right? If the court were to see fit to release and make a no contact order with the alleged victim in the case, is it your opinion that Mr. Latina would follow that order?
Yes, sir.
And additionally, with the
Absolutely.
imposition of a GPS monitoring device to be monitored, that would
Yes,
also,
absolutely.
but also communications, online communications, telephone, those types of stuff, any contact at all. Is your opinion he would follow that order?
Yes, sir.
Pass with it, Sean.
Ma'am, were you aware that your son got into a fight in jail this weekend with another inmate?
Yes.
What did you know? What do you know about it?
I heard that he was trying to fight my son and my son put him in a headlock as to not fight him, to defend himself.
So apparently that's something that he told you,
Yes,
but that's an incident that occurred this weekend right before he appears in court, correct?
yes,
Are you also aware that he had another jail incident on March 21st? It's only been in there for just, what,
35 days,
35 days?
36 days,
Are you aware of that incident?
possibly. I mean, we talk about a lot. I only recall this last one.
Where a nurse alleged that he was being rude and mistreating her?
No, sir, I don't know.
Never heard anything about that.
Yes.
Before I told you about that, would you have expected that conduct out of your son?
No, sir.
Certainly the stalking charges don't fit within the conduct you're aware of either, is it?
I am aware of the situation.
I meant you wouldn't expect him to actually stalk somebody.
No, sir.
Right.
Absolutely not.
So when you made the representation to the court that he would abide by terms,
Absolutely.
that's what you would have thought before the stalking charges came up
Yes.
as well. So how much money today does the family have to try to help him post a bond?
Again, Your Honor, object, it's not the family's responsibility. I believe under the law, it's the defendants. They're not required to. And as far as a consideration, it's not the family's financial.
I'll rephrase the question. Has there been
It's
an
what possible assets he may have.
If he has.
And
yes,
if
Your
the
Honor.
family is willing to help him, that would be an asset that he could possibly use, but go ahead.
So what's the amount that's been raised to try to get him out of jail?
Well, if the bond was dropped to 5,000, we'd be way better off to be able to help him. Even 10,000.
My question was, what amount has been raised what amount do y'all have today to post for a bond?
I mean, we haven't discussed that. My
So
husband-
there's no dollar amount that y'all have.
Not at this moment.
Okay.
But we are willing to help.
Understand. That's what,
Nothing further, Your Honor.
Anything else?
No, Your Honor.
Okay, what else do you have? You can be excused, ma'am. Thank you. What else did add?
I really don't want to call him as a witness, Your Honor. I think that it's sufficient from what his mother, what elicited from his mother for the court to look at
Yeah.
his conditions.
Right.
And then, of course, I mean, I guess I can just like briefly call him as a witness then. Frazier.
I think, have you been sworn in already? You solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
yes, sir.
Go ahead.
You heard your mother testify about your banking account, savings account, checking account. How much liquid access do you have? As far as money in a bank or something that you can access?
800 to 1,000.
Which bank is it in or Trinity?
It's actually a life insurance policy.
Oh, okay, so you don't have the money on deposit anywhere?
It may be in my bank. I'm not sure. I've been in jail. And then I also have the motorcycle side by side, the full load wing. Some other things I could probably sell to come up with another 500 to 1,000.
Well, would you have to be out of jail to facilitate the sale of those items without a power of attorney?
Absolutely.
You have any real estate, rent houses, property, this kind of things?
That's what I'm getting.
So I guess you have a cash value in your life insurance policy, is that what you said?
Yes.
What is the cash, I guess, cash value of that?
It could be higher now, but when I checked it, it was about 850.
$850,
Yes.
and that's the 850 you're referring to then?
Yes.
All right. So you don't actually have $800 or $1,000 on deposit in a financial institution?
No, I was in the process of cashing that out before I got arrested.
All right. Should the court release you on bond? Your mother indicated you resided in Hardin County, is that correct?
Yes, sir.
You own that house, or do you rent there? What's the situation?
I rent it. And rent is paid.
Okay. Would you make all of your court appearances, show up to court?
Absolutely. No question.
And if the court orders a no contact with the alleged victim in the case, you abide by that?
Absolutely. Absolutely.
And again, if the court orders that you install and maintain a GPS device, you would do that?
That's not a problem. Yes, sir.
Ask witness.
Didn't Judge Derun order that you have home confinement and a GPS monitor?
Brandon, if you could be clear.
The judge that arraigned you when you set the
Yes, sir.
The question is, when you were set the $100,000 bond, did it include the conditions of home confinement?
Yes, sir.
Did it also include the conditions of a GPS monitor?
Yes, sir.
All right. So what efforts have you made to raise money towards the bond as it is currently set?
I've been in jail, so I didn't actually find out about a lot of this till in February.
Right. So you currently today, you haven't done anything to try to sell off those assets or find out how much money you've got in your bank account, correct?
Yes and no. I put a few things online, but I didn't get the chance to really go anywhere with it.
So you really haven't had the opportunity to try to put together funds to try to make the current bond amount. I made the representation to the court through my questioning of your mom. She had 2 different jail incidents. Is it true that on April 13th, that would be Saturday, that you were involved in a physical fight with an inmate by the name of William Woodley?
Yes, sir.
And that all occurred knowing that you were coming to court. You knew you were coming to court, right?
29th, yes, sir.
Yes, sir.
I didn't want to fight.
But it happened.
Yes, sir.
Likewise, you also had an incident soon after you came into custody where a nurse alleged that you treated her improperly.
That was actually a male nurse, sir.
I'm sorry. A nurse alleged you treated them improperly. That's the accusation, correct?
That is the accusation.
Has there been a finding by anybody on that? Meaning, once the issue has been done, has there been a finding by a court or anything there at the administrative level?
I asked for them to check the camera systems. No, sir. They didn't want to do that.
Right. Did you receive disciplinary action?
3 days restrictions.
So the answer is yes. You were
Yes, sir.
disciplined for that conduct.
Sir.
No further questions of this
Didn't
witness,
sign that
Judge.
form.
What
I didn't actually sign that form.
was the 3-day restrictions for the incident with the nurse or for the incident with the other inmate?
No, it was for the incident with the nurse, the male nurse.
Was that when you were going through intake or when was that?
No, it was about 1 a.m. I was having pain and they told me they refused to see me for the pain and I just quit talking. And then next thing you know, I'm being written down.
Okay.
Say it again. Next thing you know, what?
Next thing you know, he called the jailers to come in. They didn't hear our conversation, but the write-up alleges I was yelling. And next thing you know, they're writing me up because I wouldn't talk because I didn't know what to say. I don't disrespect them.
Very good.
Disrespected. And I guess there's no incident report that can be tendered.
I can if you want, if you're not going to object.
Again, we're going down a side trail here. Your Honor. Obviously, jail is what it is.
Anything else?
No.
Anything else?
Not from the state, Judge.
All right. The issue on bond is dealt out clearly under Article 17.15 of the Texas Code of Criminal Procedure. The rules for setting amount of bond. It shall be sufficient to give reasonable assurance that the undertaking will be complied with, that is, appearance in court. The nature of the offense and the circumstances under which the offense are committed are to be considered, including whether the offense involved violence as defined in Article 17.03 of 03 of the Texas Code of Criminal Procedure. And the future safety of a victim of the alleged offense and the community shall be considered. And any aggravating factors in the charged offense are included under case decisions. And the indictment that the grand jury has rendered in true bill states that you drove by and videoed the residence of the complainant, and your conduct would cause a reasonable person to be placed in fear of bodily injury or death and feel harassed, annoyed, alarmed, abused, tormented, embarrassed, or offended. Also, that you knowingly engaged in conduct, namely a text stating the defendant would assault the complainant, and that would cause a reasonable person to fear. There's a probable cause affidavit that is applied in this case that the court is going to call Courts Exhibit 1 for the purpose of this hearing.
Should include in the record, Your Honor.
Sorry?
It's included in the record.
There it is. Yes, it will be part of the record of the probable cause affidavit, which stand by. Which, and the court has highlighted the portions that the court feels are relevant in this hearing. That on August 8th, 2023, the complainant receives a text message from the defendant that he knew where she lived and has homies that live 2 doors down who are watching her. Now, it also states that the defendant has video recorded the complainant's house and passes by, ensuring that she knows he is here. He is there. In this video, the defendant is driving a moving truck and states, "You think I'm crazy now? Y'all going to see how big my balls are. If you keep my kids from me, you put yourself between me and my kids. I'm going to stop your face in, homie. Watch." Now, this video, do you have a copy of that?
Yes.
Okay.
I've given you the discovery, released it to you, right? Whatever reason, shall not those for your record. Yes, it's
Well, the probable cause affidavit certainly is more than concerning. It's very threatening. And we are on an issue apparently where these two have children together. And there's obviously emotion here involved, but the grand jury has reviewed this case and indicted you for the third-degree felony of stalking. Thus, there are marching orders that are normal and customary for this type of offense. Your bond is at $100,000. I'm going to reduce it to $75,000. Because this court is not aware of criminal history.
There's been arrests, but no convictions. Judge.
Convictions are what are the key here. I can also, as a condition of a bond, under Article 17.46 of the Texas Code of Criminal Procedure, for a bond involving stalking, you, or if you post a bond, you shall not communicate with the victim, go near the victim's house or workplace, nor go near a school or daycare facility where the victim's children attend until this gets resolved. Also, you must have a GPS device that shows where you are at all times. And you shall not go near the victim or the children unless the other courts have reviewed this case and deemed that visitation is necessarily ordered. Until this case gets resolved, what we have to do is freeze the action to ensure that further harm does not occur and wrongdoing, additional wrongdoing is not added to this case. You're looking at up to 10 years in prison right now. Do you understand? On this charge. So that is serious. What other conditions of probation of bond would be necessary?
Based upon the discovery, the state would ask for a drug patch. And what I mean by that, Your Honor.
It says that he failed a drug test. What was, did not pass a court-ordered drug screening. What was that?
They took a hair analysis, Judge, which my understanding.
Why was that done?
It's part of the court proceedings that were ongoing in the 88th District Court there in Hardin County.
Oh, okay.
The result shows that he was positive for cocaine, positive for oxycodone, positive for THC. So based upon those results, I would ask that there be a drug patch additionally as a condition of bond.
Again, Your Honor, that's an additional expense. So perhaps the court could drop the bond a little bit more if you're going to have a drug patch as well. Yeah.
Well, you've read it. You've got a copy of the indictment, the probable cause affidavit. You've got a copy of that. If you don't, I've got a copy for you. So we've got to, these are most serious accusations, most serious. And we're not just talking about the mother of the children, but children are necessarily involved here. You're their father, right? I'm a father. I can't imagine putting my children into a position where they're afraid, or in an environment like this where their mother feels threatened. It's for you to fix. You got a mess here. You got to figure out. But what we got to do is ensure that harm is not done from here on. But these are quite serious accusations, and what we're trying to do is to separate everybody until we can resolve this under the rules of law as soon as we can do it. And that means everybody's going to move to the corners until we can resolve this as soon as we can.
We set it for announcement.
What you want to announce now?
I'd like to really have an opportunity.
How much time? 3 weeks?
Yes, sir.
Okay, I'll reset 3 weeks announcement.
Okay. We can make it.
Yeah, drug patch and GPS device. Sir, if you happen to post a bond, or get a bond posted, do you understand how important those rules are?
I do, I won't break.
Yeah. Okay, that's all. Here, this is, the battery's dead on that one. Okay, do you have something, David?
Yes, sir.
What is it?
Mr. Ozane had, please.
Okay, let's go, Mr. Ozane. This is gonna be presented.
Mr. Davis.
I'm gonna do about 1:30.
Here, I don't.
Ryan said he could be here.
When do we have a jury coming in?
One.
Okay, well, we're picking a jury. We're gonna have to reset that for another day.
Oh, you had me ask him.
Yeah, sorry.
We have to do this guy on the record then. Ozan.
Yeah, we're gonna do Mr. Ozane. We're doing
Not the
that.
plea, there's another Ozan. Javier. It's a commitment thing and it has to be done today. The defendant signed a waiver, but we have to put it on the record for today. Do it at 1:30. It's Joe's. That's why he's waiting.
And here here are the numbers. Okay. Mr. Ozane, you've got, looks like 3 cases here. I have 23,515 and 23,6027 motions to revoke probation in those cases. 23 CR 1109 is a new case,
Yes, sir.
correct?
Yes, sir.
Correct, Your Honor. You were charged, you were on probation for unauthorized use of a motor vehicle and illegal possession of a controlled substance. And then and that was all on February 7th, 2022. 10 years in prison, probated for 10 years. And then we're accused of public intoxication, driving while intoxicated, unlawful possession of a firearm by a felon. All of those are on different dates. Then tampering with physical evidence, which is on the same date as the illegal possession of a firearm by a felon. All right, let's get to the bottom line on this. What is our plan?
Your Honor, it was an agreement of a cap of 7 years.
Yes, sir, Judge.
Okay, is that what it is?
Yes,
Yes,
sir.
sir.
Okay, I'm just curious where we were headed on that. All right, does the defendant waive formal readings of the motions to revoke probation on 35415 and 36027 and the indictment in 1109? Can we proceed in summary?
Yes, sir.
In summary, and you are Mr. Ozane, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God. So lower your hand. In summary, the motion to revoke probation in both 35415 and 36027 similarly state that on February 7th, you were sentenced to 10 years in prison, probated for 10 years in this court for unauthorized use of a motor vehicle in 35415 and illegal possession of a controlled substance in 36027. Is that true? I'm just going to go on 3. Okay. Allegation 3 in each of these motions allege that you committed the offense of unlawful possession of a firearm by a felon on or about April 23rd, 2023 in Jefferson County, Texas, which is what this new indictment alleges in 23 CR 1109. Do you understand what you are charged with? And is that allegation number 3 in these motion to revoke probations cases, are these Is that allegation and number 3 in each case true and correct as it is alleged?
Yes.
And are you pleading true and correct to that voluntarily and because it is true?
Yes.
Do you understand by a knowing and voluntary plea accrued to a violation of probation, that is enough to grant the motion to revoke probation? Your probation could be revoked. You could be sentenced to no less than 2 up to 10 years in prison. Knowing that, do you insist on pleading true today?
Yes.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. There's an agreement that's been reached where you would be pleading guilty to this 23 CR 1109, this new case, and then sentenced to 7 years in prison. The motions to revoke probation would be granted. You would be revoked and sentenced to 7 years, up to 7 years in probation.
Yes, sir.
And those cases, so no less than 2 nor more than 7 years, and those cases would run concurrently. Is that your understanding of the agreement in each case? If I follow this agreement in each case, you have no right of appeal. Do you understand? And how do you plead in this 23 CR 1109? Guilty or not guilty? That new indictment charging you with on or about April 23rd, 2023, committing unlawful possession of a firearm by a felon being previously convicted in 2008 in the 252nd District Court of illegal possession of controlled substance. Are you guilty of that?
Yes.
Are you pleading guilty voluntarily, knowingly, intelligently, and because you are guilty?
Yes.
This is a 3rd-degree felony. You are facing by law a term of not more than 10 years or less than 2 years in prison, and a fine may be assessed not to exceed $10,000. But there is an agreement that's reached that whatever sentence shall not exceed a cap of 7 years. So you're looking at no less than 2, no more than 7 years, deferred or unadjudicated probation, regular probation. Those sentences, whatever they are, will run concurrently with each other, the other 2 cases on the motions to revoke probation. So you understand you're looking at, if I follow these agreements, no less than 2 nor more than 7 years confinement in prison or continuance of probation in the probation cases as well. You have several options here.
Okay.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Going to show you in each case what's marked as State's Exhibit 1. Did you sign those documents voluntarily?
Yes.
Understand them, discuss them with your attorney? Are the contents true and correct?
Correct.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. This states you are mentally competent to enter your pleas, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them in each case, and the motions to revoke probation and the 2 motions to revoke probation cases. You know what you've been charged with. You were guilty of those allegations, number 3 in each case, which coincide with the new indictment 23-1109. The elements of that new indictment, you are pleading guilty and true to those allegations voluntarily, knowingly, intelligently. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses, and totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so?
Yes.
States Exhibit 1 is made a part of the record for all purposes. Without objection.
Without objection, yes, sir.
Okay. All right. Do we want a pre-sentence report or move forward? You want me to play the Jeopardy theme?
Ms. Davis, the probation officer, is here. And basically,
He certainly would probably be the person who would be able to fill in a pre-sentence report. She's here. What do y'all want to do? Ask her some questions, move forward, or call her to the stand? Or
we could do that, Judge, as an alternative to incarceration in the institutional division. Mr. Ozane would request the court leave him on probation on the cases he is on probation, place him on probation on the new case, and order him to have in-house treatment through the Burke Center, which is a medical in-house drug treatment. And I'm not familiar with that very much, and I'm not sure if Miss Davis is. But that's a background that we're trying to convince the court would be in the best interest of society, is to use this alternative instead of incarceration.
Anything, State?
Thanks, Your Honor. Just, yeah, and based on the defendant, he's been given a chance on both these probations here and continued to commit offenses in there. State believes that we're asking for 7 years TDC. Based on that, he's already been given a chance and knew the potential consequences of that if he didn't follow the probation conditions and requirement.
One other thing, Judge.
Yes.
It's my understanding that Mr. Ozan has applied and already has a bed reserved at the Burke Center, as opposed to just having to wait with some of the other drug treatment programs that I'm aware of.
Okay. Remember how we were going to this new case that you pleaded guilty to here, which is the main reason that is the focus of the motions to revoke probation here. Anything you want to add? You don't have to say anything, Mr. Ozan, but anything you want to add about what happened that night? It looks like it's 8:38 in the morning when you were stopped.
Yes, sir. I was on my way to bring my cousin out of the clothes out of the trunk. And I didn't know it was in there until they popped the trunk and seen all the clothes in there. But like I said, I know I'm 8 years, so I was trying to bring him his clothes because I was on the wrong side of the street. Yes, I was. But it was just to drop out these clothes. I didn't even know it was in there, but it was too late. It was already in there. And when they popped the trunk and I seen it, I'm like, oh man. I just stood up and like put my hands behind my back. I wouldn't be riding around with no unauthorized use to carry a gun, and I'm already know I'm on probation. You get what I'm saying? I wouldn't be.
So would you say that that's really the crux of any violations would be surrounding this gun thing? This is what you failed to do on probation, is have that gun in the trunk?
Yes.
Anything else?
Let's see.
What about the drugs that were on you? Yeah, of course, that's one of the violations of probation, and that's important. It says they patted you down and a baggie of marijuana was on you.
Yeah, yes, sir.
Did you forget to add that?
No,
If you're being forthright with me, that's a crime.
I
And
really had forgotten.
and that's a
about the
vice.
marijuana.
You forgot about it.
Yes.
Slipped your mind.
But we was talking about the gun. I ain't one thing about that.
Probation, anything you would like to add, please, ma'am?
Well, the last time I seen Mr. Ozan, he stopped reporting after he picked up these new offenses. And the last time he reported to probation was February 2nd of 2023. So after that, it's like he was.
So he's been an absconder?
Yes.
When was he put in, when was he arrested ultimately?
For which offense?
After the failure to, when he quit reporting, when did he ultimately become arrested?
Oh, it was on April 3rd of 2023 and April 13th, 2023 and April 23rd of 2023.
He was arrested 3 different times?
Yes.
And well, on that last time, was he kept in jail? Has he been in jail since then?
Since this last time? No,
Yes,
sir.
ma'am.
Not when on this last one for April 23rd, 2023. I think he stayed like 3 days and he was released.
Okay, when did he ultimately get into the orange jumpsuit he's wearing today?
March 14th.
When?
March 14th.
Of this year?
March 14th of this year.
But he was an absconder.
Yes.
Oh, did they catch him? Is that what happened, or did he turn himself in?
No, he got, I'm not sure what happened on March 14th, how he got arrested.
That's kind of interesting. Anybody want to add what happened? Because he was on the lam for about a year. And how did he get arrested? Anybody?
I think it was in Chambers County or Montgomery County. He had got stopped and then they just extradited him to Jefferson County.
Okay, there was a warrant out for him.
Yes, sir,
For the, I
until-
guess, the new indictment as well as the motions. Is that right?
Yeah, I basically told my friend, I'm tired of running. I'm ready to just get this out the way.
Okay, so you quit reporting, you kind of walked off the job for a year, reporting? You just quit doing that?
I was scared, Mr. Stevens.
You were scared of what?
I was going to jail. I had just lost uncle that my grandma is dying right now. So I really just trying to I didn't know what to do, really. I didn't know what to do.
You knew what to do. There was a warrant out for you. You knew what to do. It was a matter of time. I'm glad they didn't converge on the funeral and make a big scene at a funeral because you were absconding. Yes. These are responsibilities that you have to deal with more maturely. And we made a big deal about this when we placed you on regular probation. These were serious, and you were found guilty, so you knew that we were serious about it. You were placed on probation on February 7th, and then a year later, here you are with a new crime. Plus, it didn't take you long after you were put on probation that you walked off the job and quit reporting. You were all right.
Judge, one other thing.
Yeah.
To point out to the court.
Yeah.
As part of the probation orders that he is currently on probation for, there was a considerable amount of restitution. I'll point that out to the court.
Okay, what's the amounts, please?
1,280.
Which case?
Actually, I think it's in both cases because it was ordered to be paid from one case and put on the order in the second case.
I don't but I won't say it. It's one case. Let me look at 1109. Nope, that's the new one. 36026.
I have an order here signed on May the 19th, 2022. In cause number 20-35415. Ordering the.
Wait, what cost? Oh, 35415.
Yes, sir.
Yeah.
And it appears to be restitution from a misdemeanor. It's a 6-digit case.
Was that? I don't have that in an order I signed within probation order here. It's not in the probation order. It's not in the judgment.
This was May the 19th, 2022, which was about a few months after he was originally placed on probation. I believe probably what happened, although I'm not.
Do we have any
sure.
help on that? Anything we know?
No, sir, it's not even in his,
I'm not showing it.
Yeah, I'm not showing it either.
It may be in the misdemeanor case. I'm not sure I could order it anyway from an adjacent case. Okay. There's my signature, huh?
And it appears to be one of these cases, Judge. I'm not.
Let's see. 6/3/22. Okay.
2023, 22. And order amending provisions of probation.
I believe that amount has not been paid.
Here's the file. Find that, please, in that file. Thank you. And was anything paid on that?
No, sir.
All right, well then, if nothing further, then I'm going to find that there is sufficient evidence supporting these motions to revoke probation, to grant them by a preponderance of the evidence or greater, as allegation number 3 is proven true.
I didn't have it in there. Sorry, sir. It's not there.
In his motions to revoke probation in cause numbers 236027 and 235415. And in 23 CR 1109, I find that the defendant has pleaded guilty voluntarily, knowingly, intelligently, and there is sufficient evidence supporting that indictment beyond a reasonable doubt of all the elements of the crime. I hereby find the defendant guilty in 1109 of that 3rd-degree felony of unlawful possession of a firearm by a felon. In each of these 3 cases, the motions to revoke probation are hereby granted in 235415 and 36027. And I'm following this agreement that he, on those motions to revoke probation, where the defendant was placed on 10 years probation, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years on each of those 2 cases. And in this new case, you were pleaded guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. On this new case 1109, you were hereby found guilty beyond a reasonable doubt. I am following the agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years. Each of these 3 cases shall run concurrently. Do you understand what has happened today? That is all. We are in recess. Thank you. Any other pleas right now? No, we are in recess. Thank you.